your patience. We had a last-minute meeting that we had to complete this morning, which resulted in a few of us being late and having to have this meeting at a slightly later time. So we appreciate your patience. My name is Kayla Murray, and I'm the Standing Committee Chair for Finance, Economic Opportunities and Tourism. And it's a pleasure to have you all here today. So without much further ado, I'm going to hand over to the members to introduce themselves, and then over to the officials to introduce themselves.
Good morning, Andrikus van der Westhuizen, member of the committee.
Any other members who'd like to introduce themselves?
Khalil Brankes, member of the committee. Good morning to all the members and colleagues.
Morning, I'm Nomin Kondra, member of this committee. Thank you.
Mbulelo Isaac Seleku, member of the committee. Good morning.
All right, thank you very much. We'll now hand over to, I'd also like to just recognize Member Lund, if you'd like to introduce yourself.
Good morning. My name is Jacques Lund, and I am the NCOP member that will take whatever you mandate me with back to the select committee and try to get those points put forward.
Thank you very much. And officials, over to you to introduce yourselves.
Chairperson, good morning, and to the colleagues on the platform. My name is Romeo. My surname is Master. I'm the legal advisor assigned to this committee for some support. Thank you, Chair.
Thank you very much. I understand that we are joined by Batanda, who will be briefing us on the first bill. Would you like to just briefly introduce yourselves?
Oh, my mic is on. I didn't realize. Sorry. Morning, members. My name is Batanda Mlambo. I'm from the Department of Small Business Development. Thank you.
Thank you very much. And are there any officials from Treasury or DDAT who would also like to introduce themselves?
Yes, it's Nadia Ibrahim, Director, Provincial Government Supply Chain, Provincial Treasury. And with me, I have Leanne Cupido, who's my Deputy Director. She's in the office with me.
Welcome. All right. So with that, we have no apologies received for today, which means that we can jump straight into business. I'll now hand over in terms of the briefing by the permanent delegate and the Department of Small Business Development on the National Small Enterprise Amendment Bill. So I'll hand over to Member Lund and then the department thereafter to do the presentation.
Thank you, Chairperson. So my job is actually quite easy this morning. Ms. Mlambo will have the longer and more difficult job this morning. We have already received our briefings in the National Council of Provinces. So in short, basically, I will listen to the comments, but when this committee gives me a negotiating mandate, I will take that to the select committee. We'll try and put the Western Cape's position, try and convince the colleagues from the other provinces of the validity and the importance of many positions that you put forward. And then obviously you'll have to give a final mandate, and then we will need to vote that through. Now, this is, if I err now on the side of giving my opinion, this is one of the pieces of legislation where I think we can actually find one another across party political lines. There's one or two small matters that can be looked at and found a middle ground be found. But this is a piece of legislation that came through quite late. So I know that the members here are under a lot of pressure, but I do hope that we can find one another here and in the select committee and get this through, and will add value as a legacy from this sixth term of Parliament. So Chairperson, that's all from my side. I will stay on, and then I hand over back to you to take the meeting forward. Thank you so much.
Thank you so much. And with that, I hand over to the department.
Thank you once again. Honorable members, as I've introduced myself, I'm from the department, Bathandra Mlambo. I believe you might have received the copy of the bill is there. I saw it on the pack. There's a presentation which was shared with the select committee. I'm not sure if you had received it, but I will share from my side because at least it summarizes the objects of the bill rather than going to the bill line by line. With your permission, Chair, will share. If you can just confirm if it is showing on your side.
Yes, I can confirm. It's just not in slideshow mode yet.
I suppose it's on slideshow now.
Perfect. Thank you.
Thank you. Okay. The department is introducing this bill. Just a way of background, the department has done its part. We've done the public consultations. We've received inputs from the public. The bill was presented to cabinet, and then after all the issues were noted, and then we ultimately submitted to Parliament. The National Assembly dealt with the matter. We requested to come and present the bill, and then after that, they had the public hearings. We requested just to clarify issues where Parliament or the National Assembly needed a clarity on the issues through the portfolio committee. So I take it now is the turn of the select committee to that. So we've just been requested to present the bill so that the members of the public can engage on the bill, and then afterwards, if there will be issues of clarity, then the department might be invited at the end after all the provinces have made their inputs. So the department can clarify on the points of clarity for the honorable members then to decide, are they fine with the bill, which issues they retain, which issues they need amended on, and so forth, on whatever their inputs. Those are the areas that I will cover, but I won't go into that. I will just zoom in, so let's just shoot in into the presentation itself. Chairperson, the bill, the National Small Enterprise Amendment Bill, I just referred to the bill. The aim of it is to amend the National Small Enterprise Act of 1996. And those are the 5 areas that it seeks to do, is to provide for the incorporation of CIFA, which is currently one of the entities of the department, the CPDA, which falls under the National Treasury, as well as the CEDA, and then all those 3 combined to form one entity, which is CIFA. Also within the bill is the establishment of the Office of the Ombuds, and also it provides some powers to minister to declare certain practices in relation to small enterprises to be prohibited as unfair trading practices. And then it also gives some powers to minister to amend the schedule to the Act and then amend the definition of a small enterprise. First one, the CIFA, which is the new entity that is being proposed. The purpose of this entity is to give effect to a cabinet decision to enable and provide for integrated government support, both financial and non-financial, to small enterprises, including co-ops. Also, it talks about rationalization of the SOEs as one of the cabinet decisions. Members, as I've indicated, will be aware. Currently, we have CIFA, which is one of the entities in CEDA. And we often receive complaints that the process are cumbersome. Someone who starts a business will first go to CEDA, get a business support drawing of their business plan. After that, long process is done, and someone has to go to CIFA if they still need funding, which has got its own processes. At times, you find that one would have been approved by CEDA, but when it comes to CIFA, there are issues. So the purpose basically is to try and rationalize those and have everything in-house. There's also CPTA, which deals with co-ops on one side, which are also small businesses. So it's trying to incorporate all those 3 entities into one so that the process at least is tried to be streamlined and shortened. The purpose of CIFA will be to ensure that small enterprises and co-ops and ecosystem is able to offer the most efficient business advice, business development services, investment support, business facilitation, incubator support. The vision of the CIFA is to be a leading business development entity that will drive economic transformation and inclusive growth in the economy through ensuring provision of customers' financial and non-financial support and greater access to finance for SMEs, which is what I've spoken about. Then the bill provides that SAFA will be an SOC in terms of the Companies Act, with minister being the shareholder representative on behalf of the government. And then SAFA obviously operates under PFMAs. The money will be appropriated through the fiscus, and also it has to comply with the provision of the Companies Act. Also, the bill sets the criteria and composition of the board, which will be in charge of the entity, and also speaks about the board committees, which will include the audit and risk committees and the rest of the committees that usually are developed in any SOC. And then we move forward. Why, if we move now to the Office of the Ombud, why are we having the Ombud? Why are we establishing this? The mischief that the bill seeks to remedy is the lack of effective and affordable access to a justice mechanism for small enterprises. Business-to-business disputes and late and non-payments of legitimate invoices are a significant reality in the lives of small enterprises across the world, with very real implications on their growth. I think honorable members will be aware that we receive complaints from time to time about ill treatment of small businesses. Some do not have way to go. If they have to litigate, it becomes a process, especially if you're litigating against big companies or government. So it becomes a cumbersome process. So basically, the Office of the Ombud is trying to see how can this be fast track. How can the government provide an easy and fast way for small enterprises to attain justice for their businesses. In terms of Section 34 of the Constitution of the Republic, the section provides that everyone has a right to have any dispute that can be resolved by the application of the law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal forum. So basically, the establishment of the Ombud is basically to try and establish this independent or impartial tribunal or forum. We are saying, as I've indicated above, the litigation route for resolving disputes places SMEs at a significant disadvantage relative to their larger business counterparts for at least one of the three reasons. It could be more. The financial cost involved is too heavy for small enterprises, even when the amount involved is large. Going to court is still a prohibitive proposition for small enterprises. You know the role of the court, especially if it's like court, it can be within months, and at that time, the small business can go under because they wouldn't have received what is due to them. So it's best to try and avoid that if possible. As I've indicated, the process is cumbersome, it's time-consuming, and very expensive, depending on the pockets of that small business. The bill provides that the Office of the Ombud is a juristic person and sets the criteria for appointment of the Ombud. And also in the Act, if you'll read, the Ombud is accountable both to Minister and to Parliament. Then the bill provides for the functions of the office to be performed by the Ombud and assisted by the deputy in operating in regional offices when necessary. Also, like any other entity, it's subject to PFMA. Within the functions, within the office, how does it operate? The bill provides for the office to consider and dispose of complaints in a procedurally fair, informal, economical, and expeditious manner, and by reference to what is equitable in all the circumstances, with due regard to the contractual arrangement or other legal relationship between the complainant and any other party brought to the complaint. Then the Ombud will provide a full suite of services from complaints handling to investigation, ADR, alternative dispute resolution, your education, contracting, practice model to assist small enterprises to draft and sign fair and sound contractual agreements. So it's basically more of guiding them in areas more than providing dispute resolution, but to provide on guiding them how they go out in resolving their issues. And then the determinations or outcome will be in writing. And obviously for PAJA purposes, there must be reasons for such outcome, because one might want to challenge the issue for whatever reason. So for PAJA purposes, then it has to be in writing. Determinations by the Ombud are mandatory and binding and providing ADR mechanism with aim of avoiding litigation, which is expensive and time-consuming. Obviously, like any decision by an administrator, provision is made for judicial review, especially on the grounds of illegality, procedural unfairness, or irrationality, thus still protecting the rights of persons involved. So like any decision taken by the administrator, it can be taken for review if one feels aggrieved that for whatever grounds the Ombud may not have followed the due processes in coming to a decision. Coming to unfair trading practices, this is covered on the bill. I think it's section 17Y, if members want to go into detail when it comes to the issue of unfair trading practices. Basically, here the bill enables the minister to declare certain trading practices in relation to small enterprises to be prohibited unfair trading practices. This is done on the recommendation from the Ombud. Obviously, the bill will not give minister unfettered power, so the bill will set parameters and procedures in terms of which the minister have to provide a notice in the Gazette before declaring such practices to be unfair. This could relate to a lot of things. However, before minister does that, before issuing such notice, the minister must consult first with the Minister for Trade, Industry and Competition before issuing such. So whatever minister does to say this trading practice is deemed to be unfair, then there has to be one consultation with Minister Patel at the stage, or whoever the minister will be at the time. Also, number two, the minister has to indicate the intention and reasons why such practice is declared to be a prohibited unfair trading practice and must be published in the Gazette for public comment. Further than that, following the publication of the intention to declare such practice, then the minister must also consult the minister responsible for the national function that will be affected by such declaration. So it will depend which area that such practice is deemed to be unfair. Then the minister also has to consult her counterpart in that department to indicate these are the measures or whatever is being proposed to be addressed as being an unfair trading practice. We move to the definition of small enterprise in terms of size and criteria. Currently, honorable members, the categories are that we have a small, there's a definition of small, there is very small, there is micro and medium. Also, it talks about the criteria for number of employees, turnover, and total gross asset value. So as it stands from the inputs received is that category very small it does not make sense, and therefore it has to be removed because there is micro. So as it is proposed that going forward, the category of very small be categorized under small, because as I've indicated, it's found to be repetitive and is not useful. So if that is approved, then going forward, will align with international practice, which is MSM or MSME, which is your micro, small, and medium instead of SMME. So then also we'll be removing the criteria for the asset value in terms of the definitions. This is more on a procedural matter going forward, which is the amendment proposes basically it gives minister powers to amend issues relating to the schedule. This is just a background which I spoke about earlier on, honorable members, that as a department, after we're done, we presented to the portfolio committee. During that period, they consulted, and then after that, the department was asked to provide inputs of clarity, because the process in Parliament is just to provide inputs of clarity, and then for honorable members to decide, are they happy with the bill, where do they want amendments? And then after that, the bill also obviously is with bill. It's before now the NCOP. So this is where we are. The minister was invited before the select committee, and then she presented on the 6th of February, basically what's similar to what I'm doing now. And then now we are told the select committee is doing public consultations, which is this process. And then once all the issues to be raised by the public are received, then the department, we believe, we might be invited again to appear before the Select Committee to clarify issues where it is not certain, but as I indicated, to clarify issues. When it comes to the content, obviously the process, the department has made their input, so it will not be to influence the content of the bill, but just to clarify. But it will be up to the members to decide, are they happy with the content, which issues are they not happy with. But since the process is with Parliament, the department has done their part to influence or to contribute to the content of the bill. So it's up to the members. So ours will just to clarify where it is not certain and then leave to the members to make a decision without the interference or influence from the department. Chair and honorable members, I will pause there and then allow questions of clarity, if any. Back to you, Chair. Thank you.
Thank you very much. All right, members, if you can please raise your hand to indicate whether you have any questions. Okay, I see no hands. So just, okay, here the hands are. First hand is from Member van der Westhuizen and then from Member Nkontlo.
Thank you, Chair, and thank you for the presentation. Chair, I appreciate the challenges for smaller enterprises, but I'm also simultaneously concerned about a proliferation of, ombuds, a proliferation of, boards and so on, which places an extra burden on, for example, the taxpayers of this country. Now, my question is just, have you got any idea of the additional costs which may be stemming from this amendment, from this legislation? And then secondly, have you considered, for example, expanding the mandate of existing offices that we have already, such as, for example, the consumer tribunals, etc., to also not only service members of the public, but perhaps also include under their mandate the issue of giving support or acting in the best interest of small enterprises, so that also small enterprises would be able to lodge cases of unfair treatment, etc., with such officers. Thank you.
Thank you, Member Nkontlo.
No, thank you, Chair, and thank you for the presentation. I just need some clarity. Firstly, I think on the Ombuds office, because I'm trying to check, and I'm sure in the assessment of business case to really put this in this office together, some background research would have been done, because I need to understand. One of the challenges of Ombuds offices generally has been their effectiveness, and the mere fact that whilst I think the colleague speaks about, the issue of access for small businesses, but the tedious and elongated processes in Ombuds office for people to prove. I'm not sure if any referencing or benchmarking has been done just within the space or even in other countries versus, just Ombuds in general as a mechanism for recourse and its efficiency. That's just one issue that for me, I think I would like to understand. And also how the Ombuds, because depending on what are the presumed grievances of the SMMEs, how do you link this to, for example, the process of the competitions regulatory framework, and other related the processes, for example, within a government. Let's say somebody has got a query about them not being paid. I'm saying if perhaps the grievance is about issue of payment within a government department across the 3 spheres. I'm trying to understand really how the Office of the Ombuds in this context would work. So that's just my first question. And I'm saying the second part, Chair, is just to understand, and if there is available that work that the department would have done, you know, about demonstrating the efficiencies or some of the weaknesses of the separation of the 3 entities that now are going to come together into the SITFA. You know, whilst I think personally once one supports the consolidation of these entities, because in the absence of them working coherently, you know, and in a complementary manner, which is what I think most SMMEs have been frustrated about, you get a serious wastage or loss of resources by them as they work individually, and how such would be kept, you know, in and when you start to consolidate. So I'm interested to understand the mechanics now of how this new entity is viewed, that it's going to work, whether there is something that one can be able to read from the department, you know, to help one understand how that model has been proposed. Thank you, Chair.
Thank you very much. I think I'm largely covered in terms of questions from my side. I guess I was just more curious to find out specifically what powers would the Ombud have that, for example, the National Council Tribunal doesn't have, and then whether there is any alignment with what the bill proposes and functions that might be delegated to a provincial or a local level. With that, I'll hand back to the department.
Thank you, honourable members. As I think the honourable member at the beginning indicated that the tough task will be for me this morning. Indeed, it's like that. I will just go in sequence as the honourable members had asked the question. The first one, I think it was Honourable Member Van Westhuizen, if I'm getting it correct. The issue on the proliferation of the ombuds offices across the board and the burden on the taxpayer. At this stage, I do not have the figures in terms of the establishment of the figures to establish the office of the ombuds. Obviously, those discussions are still ongoing with the National Treasurer as and when the Act is passed, and then the regulations relating to the implementation of the bill are developed, and then a further engagement with National Treasurer, then the figures will come into play. So at this stage, we do not have the figures, but obviously it will be funded through the fiscus, through the department. But as and when the figures become available, obviously the discussions and presentations both to the House of Parliament will be done on a regular basis to provide more detail with regards to that. On the mandate, why not confined to consumer tribunals? I think it also covers to what Umamukondlo was asking below. Look, we have done, before we introduced the issue of the embassies, the department obviously we had to engage the structures representing business to see are the small businesses currently being properly represented or their issues taken into consideration. Are the structures having powers, adequate powers to address the issues that the small businesses have and the issues that at the moment small businesses are just on their own without adequate support, without proper recourse to justice. So that's the feedback that we got, that as much as the consumer tribunals, but in terms of effectiveness, in terms of having the biting teeth at the moment, that does not happen. Hence then the piece of legislation to say a statutory body is established with power powers that will indicate all the powers that we have, powers to subpoena people, powers to make determination, as I indicated when I made the presentation, that the findings will be binding. Obviously, from the once a finding is made, there are legal processes to make sure that such a determination or such an outcome made by the Ombud is effected into law. There is a system in place in the country that once a finding is made, how do we enforce that in a court of law? So there will be those processes and the powers that will be given to the Ombud. So it's basically a response to receive from the general population that this is the outcry at the moment. As small businesses, we do not get adequate justice, and with the current structures, there isn't much power that they have in terms of making sure that they are effective. So it's a response to the outcry. Then coming to Umamukondo, on the tedious process, I think it basically, I think I've touched on it a bit. Obviously, we are still to develop the regulations to the bill, but on the act, I'm sorry, the regulations to the act. On the act, it just outlines at high level what are the powers that the ombuds will have, and then it highlights how is the office going to be established and what powers. But when it comes to the actual nitty-gritties in terms of the functionality, that will be outlined at a stage through when the office is established, when the ombud is appointed, and when the regulations are established. Linked to the Competition Commission. Look, the Competition Commission does have its own area, but it doesn't really cover your day-to-day issues that affect your small business. Obviously, when it comes to Competition Commission, they will cover your broader general issues that speaks to competition issues in the country, but your day-to-day practices that involve in individual small businesses, that space is left on its own. So that will complement what has not been covered by the Competition Commission. If there's an issue of unfair individual contracts between, say, a particular small enterprise with a big conglomerate, those issues are not necessarily covered by the Competition Commission. So your individual cases will then have to be dealt with, because as it stands, that is left unattended to at this stage. I think I did speak to when we talk about the amalgamation of entities and what power there when the three entities, that is SIFA, SIDA, and CPDA, were operating on their own. I think I spoke slightly about it when I made the presentation. As it stands, we have the CPDA, which operates under National Treasury with certain budget allocated there. We have the small business development, which has a certain funding for co-ops. I'm just making an example, which is administered partly through SIDA and SIFA. And you have SIDA, which deals with non-financial support. There are processes whereby one will have to go through to SIDA in order to get an application processed when they need non-financial support, for example, for development of business plans. That takes its own processes and time. And then once you are done, then the person has to go to SIFA to seek funding. SIFA will have its own, obviously, measures and eligibility criteria, which at times is not mirrored on what SIDA would have provided when they develop business plan. So you'll have someone whose business plan has been developed by SIDA, and then when it comes to SIFA, because now SIFA will be doing a due diligence on the individual applications eligibility or not. And then while SIDA will have done an overview to say this is how the business, your business should be, but when someone goes to SIFA for funding, when they do the individual assessment, you find that the person is rejected. And the outcry is that I've been to SIDA developed a business plan, and yet when I come to SIFA, I'm rejected. So there's a lot of outcry on those issues. So it becomes better now as and when, if everything is housed together, when you develop business plan, obviously you also take into consideration the person's profile and then determine that this application will be approved. So in our view and in our assessment and in our research is that if these are consolidated, obviously in terms of the funding, the pool comes together, there is more pairs that is going to be brought in from CPDA, SIFA, and SIDA. And then when it comes to the process, it becomes easier when as you develop the business plan, you also assess the financial profile of the person if the person will be approved for the application. So for us, the process becomes faster, and it eliminates the areas where there wasn't a sync between the entities when they were doing the application or when they were developing the business plan and when they were doing the actual application. So our assessment was that the process will then be faster. At this stage, operational on the ground, the department is working together with 3 entities in working towards developing an entity. There is a business case that has been developed through the assistance of the GTEC, which basically outlines how the operations of the entity will function. That is also at an advanced stage. So that information, I think it has been shared at some stage. We did come to the portfolio committee to present. So if necessary, the same can be done to the members through the select committee if there is any, so that the business case of the entity can be outlined, which was discussed with National Treasury, and also the GTEC, as I indicated, which outlines in detail how it will try and streamline the issues and try to be more effective. Miss Maria, just want to check on the powers. On the Act, yes, the powers of the IMBAT are indicated. We can zoom in the Act if it needs be. I'm not sure if there's anything that I've left out. Please, honorable members, indicate where I've left out or perhaps where I need to provide a bit of clarity.
All right, members, are there any further questions? I see Member van der Westhuizen.
Thank you, Chair. Thank you for that explanation. Chair, I have a concern. Currently, if my understanding is correctly, the classification of small, medium, and micro enterprises are being determined by law, a schedule to the law. Now, I understand that we need to find a mechanism to provide for inflation and so on, because turnover today and turnover tomorrow may differ in value because of inflation, etc. But now my concern is that it seems to me, and please correct me if I'm wrong, that this amendment bill will now give the minister a free hand to determine the limits of what is seen as micro, small enterprises. My concern is that, obviously ministers would like to expand their field of work, by including more and more businesses under the definition of small enterprises. More and more budget will have to be allocated to these entities that report to the minister, etc. So is it so that in terms of this amendment bill, that the minister will now have a free hand to be able to determine the criteria under which the classification of micro, medium, and small businesses will fall? Or is there any board or any oversight body that will, the minister will have to report to, or that the minister will have to convince, so that they eventually have a say and determine on objective grounds the criteria for an enterprise to be classified as a small enterprise? Thank you.
Thank you very much. I see Member Nkondlo.
Thank you, Chair. And thank you to the colleague for the responses. And I think for me, on both ends, and anyway, this will be a function of the public engagement. Actually, with Member Andrekas on this other day, I think coming from one of the public hearings, we're looking or considering the whole role of the state in regulating that. There are things that I think we really need to look at whether our regulation at some point, makes things better off or worse off, or as we would normally come back, talk about red tape, that actually we add as a burden in some of the policy decisions that we make even in this end. Because I think from where I'm sitting, one of the things that one would look at and hopefully would be considered, whether in the regulations or even in the implementation, if one talks about the ombuds, that already now, if you consider what is happening within the Competition Commission, I'm just making it as an example with the effectiveness and efficiency that it has been, to try to stay true to its mandate, is the question of getting, the relevant expertise. And it's one of the things that they always cry about, getting the competition law capabilities, that is skills and expertise. Because even in the ombuds, and I think from our experience recently of having to put together one of the ombuds for the consumer, the provincial consumer office here in the province, it's very difficult. I think it's one of the things that as a country we always need to consider is the availability of the expertise of those people that must sit there and make through the role and the functioning of that office in terms of their capability, of the legal training for that particular intention of that office. So for me, I think it's one of the things that is very important. But also of saying sometimes it's about how we ensure efficiencies of those that are in offices, of either to amend a competition, an existing institution like a competition commission or any other, and ensure efficiencies. Because even the issue that we are raising now of enjoining these entities as an example, that if we're not having proper monitoring of those that are supposed to be implementing, like you indicate that people will go to CEDA, requesting support, business plans, and then they take those business plans and they go to CIFA, they either get rejected. And I mean, if you don't resolve that particular problem, enjoining those particular institutions, because it's about, the cross engagement or this thing of people working in silos. So I'm just making that as my comment, that I hear the response, but I'm just saying, I think sometimes in the bigger scheme of things, it's very easy, if we start from where the theory of change of saying we'd rather have these functions separated, and then a couple of years later, we're saying ourselves now as government, we're bringing them together. If indeed that was the most most well thought type of a decision. Now that we are consolidating, so I just wanted to make those particular comments, having considered and accepted what the colleague is giving as a response. Thank you very much.
Thank you very much. I think just from my side, what would be very helpful to see is if there were any socioeconomic impact assessments done, and if that could be shared with the committee. And also if the business case could be shared with the committee as well. I'm not sure that we'll have time for a proper briefing on that. I'll hand back to the department.
Thank you, honorable members. Starting again from top with Honorable van Versthuizen. I take it, honorable member, you are referring to section 22, which says the minister may, in order to achieve the objects of this act, by noticing the Gazette, make regulations setting the criteria to determine the classification of micro, small, and medium enterprises. I'm assuming the member is referring to that particular clause. Basically, at the moment, obviously, when minister is making such regulations, the consultation has to be done with the relevant ministry, which will be National Treasury, among others, and obviously trade and industry. So there will be that consultation and also publishing the Gazette. However, members, I'm sure they are at liberty if they feel shall I say, uncomfortable with certain powers to raise those issues. But as it stands, obviously, whenever minister has to do such critical work or significant work rather, then there has to be those consultations, and then before going to cabinet, which obviously will have to approve the whatever regulations that minister intends to impose. So as it stands, those will be the checks and balances. However, if members feel additional additional checks and balances need to be imposed, I think those can be suggested. I don't think if such is to make sure that the minister performs within her powers, that can be rejected. But as it stands, that's what it provides. So it will be more of consultations, and then through the Gazette, it's for to receive input from the general public to say, is this fine, is it not fine? So it's not like it's a closed process whereby just tomorrow it's announced. So there will be those open public consultations, and then ultimately it's taken to cabinet before it is approved. At any stage, the members of the select committee or on any houses of parliament can always invite minister to come and account to clarify the issues. So in any given time, there are those checks and balances that are available in the country. Mamukon, I'm not sure whether to respond. Obviously, I get the inputs. Others, obviously, I will not be able to respond to, but I'm sure it's more of a comment to say we should be looking at what we have more than try to introduce new things. But as I indicated earlier on, when we introduce the proposal, it is because we have done the study, and obviously we have consulted with relevant departments that are currently having similar powers. As I indicated, we've done several engagements with the Competition Commission, amongst others, and our view is that what we do does not necessarily trample on what the Competition does. Instead, it covers the area which the Competition Commission doesn't really cover, looking at the mandate of the DTI and the Competition Commission falling under them. SAYAS was done. Obviously, before the bill is passed, there should be SAYAS that can be shared with honorable members who will engage with the colleagues. The business case, I'm not sure if Honorable Mara, you are referring to the business case for the establishment of, you said this, you want the SAYAS? Ombudsman? Okay, we'll share the documents with the honorable members. Then, if there's any further engagement, then that can be arranged.
Okay, thank you very much. Members, just a final round, if there are any follow-up questions or final questions. All right, I see none. Members, then we will proceed with the next bill. I'll hand over to member. All right, I see a hand from Advocate Master.
Good morning, Chairperson. I just have two observations, and then I would like to refer to the actual bill. And to that end, I'd like to ask my colleague Sahida Adams to flag the bill, the actual bill, at the time when I asked you to do it with your permission, Chairperson.
No problem.
And why I say the actual bill, Chairperson, is because we had a presentation with a number of slides, and the presentation was a very useful and a very insightful overview, high-level input from the colleague from National. But as lawmakers, we will not be asked, and we are in fact not tasked, to pass PowerPoint slides. We are asked and tasked to pass bills. That's why, and I assume that everyone, in anticipation of this meeting, read the actual bill and the verbatim of the actual bill. Because you see, Chairperson, all of us are commonly tasked to pass laws so that in due course, when a stakeholder or an affected party, for example, a small business owner, needs to invoke a provision of that law, then the law must be of such a quality so that courts, when there's a litigation, are empowered to properly and as intended interpret a bill. Why am I mentioning this? And in this regard, just for the record, Chairperson, I don't have any substantive concerns in respect of the constitutionality or otherwise of the bill. But we are still, all of us, tasked to write good laws and not to agree to pass power slide presentations. Could I ask my colleague to focus on clause 17L? And while I'm waiting, Chairperson, these are not very substantive stuff, but it certainly speaks to just on the drafting and how we assist courts, because that's where the beauty and strength of a law is assessed, to interpret it in favor of any complaint or litigator or stakeholder. 17L, for example, provides that the Ombud may investigate a matter. Now, there's very much of a wide discretion there. That's discretion 1. But in which circumstances may an Ombud investigate? If a significant number of small enterprises are impacted. I don't know what that means. I don't know how a court will interpret that. From what I can read, a significant number is about the same length of a piece of string. And that's anyone's guess. I need for a, not I need, it's not what I need. I would recommend that a drafting approach be used to assist with interpretation of provisions so that it can be properly applied. Could I ask my colleague to zoom in on clause 17Y? Preferably 17Y. There you are. And in particular, Ms. Adams, 17Y sub 3. There you are. Thank you very much. Clause 17Y sub 3 provides for certain instances, Chairperson, where the minister, which will guide the minister and the Ombud to consider whether certain practices are to be unfair trading practices. And again, if I should teleport myself to my previous career as a litigator, if I should go to court and try and invoke this act in favor of my client, for example, then certain things come to mind. 17Y3 sub 2, Roman 2, says that the particular practice concerned has the effect of unreasonably prejudicing a small enterprise. Now, I know what that means. I'm sure there will be factual and relevant data to indicate that a small enterprise is unreasonably prejudiced. But how is that any different to clause 17Y3 Roman 4, unfairly affecting any small enterprise? Conceptually, there's hardly a distinction between those two. Even, I would argue, legally, there's hardly a distinction between something that is unreasonable and unfair or something that prejudices or impacts negatively or affects unfairly. I'm just saying that, Chairperson, we are loading this bill with elastic concepts, and we just park it there as if everyone has a common understanding of what is meant, what it purports to indicate, and that it will be commonly interpreted by any court in this country. I disagree with that notion. So I'm saying there are concepts, they're unreasonably prejudicing, which is an elastic concept, unfairly affecting, which is another loaded elastic concept. I'm arguing, Chairperson, that the drafting is a bit open-ended. It doesn't assist a future court when it has to interpret this law in favor of a stakeholder. And I would recommend that either one of those provisions be deleted, or that we properly qualify the instances that will guide a minister and ombud to decide when an unfair practice, or whether a practice is an unfair trading practice. Like I said, I don't have anything substantial or substantive as far as concerns with the bill is concerned, but just in terms of its future interpretation and possible application when it comes to litigation. Thank you, Chair.
Thank you very much for those insights, Advocate Marstal. I'm not sure if the department would like to come in at all before we move to the next bill.
I'm not sure myself, but that's the question I was asking myself, Chair. But maybe let me apologize to Advocate Marstal. We could have gone through the bill clause by clause, but I thought the members had read, and hence the option to summarize at high level. But had the members requested that instead we go clause by clause, that I would not have a problem. I sincerely apologize if maybe the expectation was that we should have done it like that. It's just that through the process, that's how we've done it with the members having read the bill. But going forward, then maybe as we arrange the meeting, then maybe the rules of engagement, maybe we should clarify ahead to say this is how the department should be doing it, as I indicated on members. I sincerely apologize. I hear the points. I'm not sure, honestly, if at this stage we should be commenting, because the honourable member is proposing amending or deleting the clause. Obviously, from the side, the department would have engaged, among others, with the Office of Chief State Advisor in indicating that the bill is sound before presenting it to Cabinet and Parliament. But obviously, you'll always get issues here and there. But since the bill is at a stage where the Select Committee or Parliament is determining if it's sound, I think I'll leave to the members to determine if they will leave with the clauses they are, or they will amend or delete others in consultation with state law advice. So obviously I'll have my views, but I think at this stage, I think it's the prerogative of the committee to decide how they deal with the clauses. Thank you, Chair.
Thank you very much. I see a hand from Member Lund.
Thank you, Chair. You may rule me out of order since I serve on the Select Committee and as a representative from the province. But I mean, this is not the first time that the department hears arguments such as this put forward. I know it was raised in the National Assembly. I myself has raised it in the Select Committee, that there are clauses here that's open for interpretation, clauses that give powers to individuals that is in a very broad grey area. So the department is well aware. It has been raised at least 2 occasions. I myself raised it twice in the Select Committee, once when the chair on that side ruled me out of order that it has not officially been presented. So this is not the first time that the department has heard these arguments. Yeah, I'm not going to give further comments on that. I'm just flagging that so that you are also aware.
Thank you very much. All right, with that, we'll then move on to the next bill. If the screen could please be taken down or unshared. and then I'll hand over to Member Lund, and then to the department to take us through the next bill.
Chair, well, I'm not going to repeat what I said previously. I will take whatever this committee put together as a negotiating mandate for myself and take it to the select committee, and all the best in your work and your consideration, and you can give over to the department to do the briefing to this committee. Thank you so much.
Thank you very much. All right, and then I'll hand over to the department. Okay, I understand, Ms. Adams, if I could just bring you in here quickly.
Thank you, Chair. Good morning, members. The briefing on the public procurement was supposed to take place at 10 o'clock, but I'll just see if I can get hold of National Treasury. I think there is an official here, but he seems to be on hold. But I'll see if I can get hold of the rest of them in the meantime.
All right, if that's the case, we could also take a 30-minute break. If members would like to take a 30-minute break and then reconvene at 10 when the department are ready. Members, if I can get an indication.
Supported, Chair.
Supported. All right, so we'll reconvene at 10 o'clock and kick off with the next briefing. Thank you, members.
No, Marie, can I be excused?
Indication from who from finance will be doing the presentation? Ms. Adams, could I ask for your assistance?
Yes, Chair. I see two of the National Treasury officials in, but I'm not sure why no one's answering. Let me try and get hold of them again. Apologies.
No problem.
Mr. Matebula is going to do the presentation and he's online. And the other colleague from National Treasury is also online, is Advocate at MP Fund School. So I think Mr. Matebula spoke earlier, so probably he must be delayed by something right now, but he can clearly hear. Thanks.
Okay, thank you very much. Mr. Matebula, if you can hear us, perhaps you can unmute yourself.
Yeah, good morning. Yes, I am here. I will be taking the committee through. And with me, of course, my other colleagues have joined, and with me in the office here is Advocate Van Schoor. So I am not so sure, Chair, if I'm audible enough.
Yes, perfect.
Oh, thank you very much. And then, Chair, I just wanted to check, how much time do I have so that I don't take too much time of the committee?
I believe you have 40 minutes for your presentation.
40 minutes. Okay. And thank you very much, Chair. And let me just quickly try and see if I can flight my presentation. Just a sec for me.
And a warm welcome to you and your colleagues. Thank you for joining us today.
Thank you very much.
Thank you.
Confirming
I'm
that
just
we can
putting
see
my
it.
presentation I'm trying to put it in a presentation mode. Thank you very much, Chair, and good morning to you, and also good morning to the honorable members of the committee. We are going to present the Public Procurement Bill, which is a completely new bill. Now, just by way of introduction, Chair, this bill was introduced in the National Assembly on the 30th of June, 2023 by the Minister of Finance. And then, of course, passed by the National Assembly in December 2023. Now, the aim of the presentation, just briefly to talk to key principles in the bill, and also the range of other aspects that are going to be prescribed through ministerial regulations within the framework. And of course, we all know that part of public procurement is to, of course, allow government to leverage on public procurement to support broad socio-economic and other policy objectives of government. Just okay. And I think I've moved too fast. Just a sec for me, Chair. Okay. And just by way of background, Chair and honorable members, this is just a bill which, as indicated, seeks to regulate public procurement in the country and also to prescribe a framework within which preferential procurement must be implemented. And the bill is premised on Section 195 of the Constitution, Section 216 and of the Constitution, which which requires transparency in expenditure control in all spheres of government, including uniform treasury norms and standards, and also Section 217, which I think everybody is aware of, which prescribes those 5 pillars. Now, as indicated, Chair, part of subsection 2 deals with the allocation of preferences in contracts, and also the protection of historically people that were disadvantaged by unfair discrimination. And of course, 2173 talks to a national legislation, which is the framework that we'll talk to later on in the presentation. I will try to ensure, Chair, that at least the presentation does not, go beyond the 40 minutes that I've given. Now, what we're trying to say, part of the aim of this bill is to consolidate the fragmentation in the procurement system. There are a number of laws in the country, as the Chair may know, and some of them, of course, causing a lot of confusion in a procurement environment. So this law will be the single regulatory framework for procurement in the country. So all other pieces of legislation that deal with procurement-related issues would be collapsed into this bill. That's the aim as well of the bill, to have just one law. Now the bill has got 7 chapters. We'll talk through those chapters just by way of background, 7 chapters, and then I'll go into just briefly to discuss each chapter in the bill. Chapter 1, of course, has got definitions, as the Chair would know. And then what we've done here on this slide, what we've done on this slide was just to lift certain key definitions which are in the bill, but I'm not going to go through them. And of course, the part of clause 2 of the bill deals with the objects of the bill, and as indicated earlier on, is premised on 195, 216, and 217 of the Constitution, and then to introduce uniform treasury norms and standards for all procuring institutions within which they will implement their procurement systems, and also to determine a preferential procurement framework for all procuring institutions in keeping with Section 217(2) and 3 of the Constitution. The objects are there, Chair, just below, and I'm sure the honorable members do have the presentation. So these are some of the objects that are mentioned in here. I'm just not going to go through them as well in the interest of time. Then the application, Chair, the bill would apply to all departments, that is at national as well as provincial departments, constitutional institutions as we know it, and also public entities. All public entities that are listed in Schedules 2 and 3 to the PFMA, as well as municipalities and municipal entities. So in other words, there would be some amendments in those pieces of legislation like the MFMA, and as well as the PFMA and any other legislation that deals with this. And then what we're also saying here is that Chapter 4 of this bill, we of course made a provision that it should apply to Parliament and provincial legislatures as well, just Chapter 4. Now, Chapter 2 deals with the establishment of a public procurement office. This is a central office that would regulate public procurement, the issue instructions, of course, issue measures to maintain the integrity of procurement system, and of course, also guidance and guidelines to support officials and procuring institutions across the country to promote compliance, and also the use of technology innovation and the modernization of the system. And also measures of transparency and then also issue guidelines as indicated. Now, it also provides for the functions of provincial treasuries. So the provincial treasuries have got a big role to play as well in the bill in terms of the issuance of guidance and instructions and so on. And of course, it also outlines the duties of procuring institutions across the country. Chapter 3 is a chapter that is dealing with the integrity of the procurement system as well as debarment. So it provides for the code of conduct for officials, bidders, suppliers, as well as the members of the tribunal and any other person that is involved in a procurement process. It also refers to due diligence, a declaration of interests, and then also it prohibits undue influence and interference in the procurement function, as well as also it provides for automatic exclusion of specified person from submitting bids, e.g. your public office bearers, employees of the state, are excluded from submitting bids to the state. And also it provides measures on how to deal with directions that are inconsistent with the Act. For instance, where people are instructed to undertake certain actions which are inconsistent with the Act. And then, of course, the big part is the debarment of bidders and suppliers that may have defrauded the state. So that's what Chapter 3 provides. Chapter 4 is that framework which is envisaged by Section 2173 of the Constitution. So I'm not going to go into at least the history. We know that we had the PPPFA, which is currently that framework, but this Chapter 4 of the bill deals with that framework. In other words, it will replace the so-called PPPFA currently. And there were a number of regulations that were issued there in 2001, 2011, and also the 2017 regulations. But we know it's history now what happened insofar as the 2017 regulations are concerned, where this matter was taken from the High Court to the SCA right up to the Constitutional Court. We know what the court said about them. And subsequent to that, of course, the Treasury, we issued a new set of regulations which are currently in place, which became effective on the 16th of January last year. They are currently obtaining. And then Chapter 4, just within the context of the broader public procurement bill, of course, as indicated, this chapter is informed by the Constitution, Section 2173 of the Constitution. That's what this particular chapter is all about, and it is also a response to what the Constitutional Court said around the 2017 regulations. So it's a direct response, and I will just go through some of the issues that are contained in this particular chapter. The chair, during the processes of the Standing Committee on Finance, there were a number of views, of course, that were raised during the public hearings, as well as the written submissions that were received as a Treasury, where people, were somehow doubting this particular chapter, and some of them saying, of course, it's a reverse discrimination. Some saying it would lack competition and it will result in the state paying higher prices and also poor workmanship and corruption, etc. But I think we must emphasize that this is not, in fact, the intention of the preferential chapter, this Chapter 4, but this is a response because this is directly from the Constitution. So there's no way you can't deal with it. And I think the court also makes that point in the 2017 regulations when it declared those regulations invalid. Now, I'm not gonna, this is just an extract from the Constitution. I'm gonna jump this. Now, some of the issues that were raised by the stakeholders during the SCOF process was that the framework in the bill that was tabled by the minister on the 30th of June was vague, unintelligible, and it did not represent the framework envisaged in section 2173 of the Constitution, and that it was not clear how tenders would be evaluated and awarded. So these are some of the issues that came out. That is why now we therefore had to expand a little bit on chapter 4, just to give content so that we address issues that were raised by a number of stakeholders through public hearings as well as through written submissions. Now, what is critical on this particular slide, Chair, that I want to point out is that paragraph number 5, where Justice Mhlanhla of the Constitutional Court during the 2017 regulations hearings, the judge makes this statement, around the fact that the standalone reading of section 2171, which ignores section 2172, is not only a disservice to statutory interpretation, but also ignores the founding values of the Constitution. So I think it's important that we note this. This is why we're saying this particular chapter 4 is a direct response to what the judges of the Constitutional Court have said during the declaration of the 2017 regulations invalid. And then there were a number of views, Chair, as indicated earlier on. Some of the views were that the framework should be discretionary. Some were saying, the framework must be mandatory. So there were different views in terms of how this framework should look like. As indicated, this chapter is that framework that relates to section 2173 of the Constitution. Now, what we're saying here is that given this divergent view, some say discretionary, some say mandatory, but at the end of the day, Parliament has got a responsibility to decide on how loose or how tight that framework is going to be, and whether it's going to be discretionary or even compulsory and so on. I think Parliament is well placed to deal with that issue. There were also other views that the framework should be centralized, from which procuring institution may implement their preferential procurement policies, whilst others, of course, as indicated earlier on, felt that it should have some flexibility in how institutions, of course, implement their preferential policies. Now, after all these views, the divergent and multiple views, quite a number of them, Chair, in excess of 2,000 comments that were received, written comments, over and above the oral, comments that were submitted during hearings. Then the deliberations as well at SCOF, and then the comments that were made, eventually then the bill was passed by the National Assembly. And I think, Chair, there is a list of the changes that were made after the deliberations at SCOF. Now, just to quickly get into what exactly is contained in Chapter 4. So Chapter 4 makes provision for set-asides. That's the one part that is in there, in that framework. So firstly, it's a preferential framework within which procurement policies would be developed by different institutions, but then it makes provision for set-asides. And these are set-asides, of course, would target specified, persons that were disadvantaged by unfair discrimination, women, youth, and then people with disabilities, among others. What we're saying also here is that we will set a threshold. This is not going to be an open, so the threshold is going to set at least the limit to say up to what threshold can you set aside certain bids for specified persons, so that you don't have an open-ended kind of system. Of course, the minister will set the targets for the set-asides through regulations. The one other part is the pre-qualification criteria, of course, and this pre-qualification criteria will also have a limit in terms of a threshold, and there would be regulations just to prescribe the criteria of how these are going to be awarded. But we couldn't put the details of the criteria in the primary legislation because it becomes a problem. Then you are stuck. You're sitting with a primary legislation that has got issues that are not supposed to be here. So that is why a number of the details on how this is going to apply will be in the regulations. But I'm sure the members, Chair, have got sight of the bill itself. The one other area is subcontracting as a condition of tender where feasible, and this is also provided for now here in these regulations. I'm sorry, in this bill, and then also the details thereof would also be outlined in much broader details in the regulations. Then the other part, Chair, is the industrialization. So we've also made provision for industrialization just to support the industrial base of the country through local production and content, so that we give preference to locally produced goods and services. And of course, this particular role is a role that we are conferring upon the minister responsible for trade and industry. But in doing so, whatever the Minister of Trade and Industry identifies as sectors to be designated for local production, at least the Minister of Finance will also have an input in that particular identification before it becomes law. The one other thing that we also say here is that these designations will be gazetted, unlike the current system. These will be gazetted so that people have got at least the transparency through what is being put out there as a designated sector. That's what we're saying. And also we're setting minimum, provisions around in what instances would the Minister of Trade Industry designate something. So anything, if there's only one supplier in the country, the minimum that we're setting there is about 3 suppliers in the country. There must be 3 suppliers in the country before any designation, any sector could be designated. Otherwise, to avoid creating monopolies, even oligopolistic market conditions. And there would be a criteria to deal with this. The bill also make provision for other preference measures in terms of clause 21, and also measures to advance sustainable development, and also beneficiation and innovation. Chair, you know that as a country, we're exporting our minerals raw, and we don't beneficiate much in the country. So what we're saying here, at least the country should be able to beneficiate. Our minerals must be processed here locally so that you create jobs and so on, unlike to send them out in a raw form and then get imported, because in that way, then we're exporting a lot of jobs elsewhere in the world. So innovation is here. So we'll also accommodate innovative ideas that people will be coming up with, including other government institutions that are created for specific purposes, like the CSIR, when they innovate, at least right now, I mean, that would be allowed to say there's innovation, and then the institutions would be allowed to go and procure those without necessarily having to find it difficult to go through all the other tender processes and so on. And then there would be regulations, of course, in here. Then, of course, Chair, the impact here is that this particular framework, which is Chapter 4, will, of course, advance policies and then, of course, and also policies that build an inclusive economy. Where have I been now? Why is this thing running away? Inclusive economy, and also promote social unity. And as indicated, unlike the current Preferential Procurement Policy Framework Act, this bill now will provide a menu of preferences that could be utilized as a framework to promote government socio-economic objectives and, of course, other policy objectives. Now, that's what Chapter 4 is all about. Chapter 5, Chair, Chapter 5, this is the actual technical part of what procurement is all about. Where we say the minister must prescribe by regulation a framework within which procuring institutions must implement their procurement systems. We're referring to strategic approach to procurement, regardless of the commodities that are going to be procured, whether you're procuring pens and pencils, textbooks. And I know that people always say, no, procuring infrastructure and pens and pencils is not the same. You know, whilst we agree, but the fact is, if you look at the education sector, they will tell you that for them, pens and pencils and stationery and books are quite critical, and therefore there should be a strategic approach to procuring those rather than just to taking off the shelf. So this is what this is providing for. And then also there will be different types of procurement methods. It's not going to be the one size fits all kind of an approach. There will be different types. And then these different types of procurement methods, it will also talk to different categories of procuring institutions. And of course, also different categories of procuring. Different commodities will be procured differently in terms of what we're providing in Chapter 4. In Chapter 5, I'm sorry. The other issue, Chair, is that now institutions are going to be allowed, in terms of this bill, to use another organ of state to deliver services, to provide services, unlike the current system. And of course, there are measures to prevent abuse in the system. And of course, there's a bid committee system, which would be prescribed through regulations. And also the use of the ICT system, use of technology to eliminate the manual intervention and human intervention in the procurement processes. So that will be promoted. It's part of what is provided for in this bill in order to modernize our system. And also, Chapter 5 provides for the disclosure of procurement information and the format in which that information should be disclosed, and as well as also the protection of confidential information, including personal information, Chair, so that we are also transparent, but not necessarily, you know, disclosing all other information which is sensitive. Now, Chapter 6, Chair, I'm almost done. We've provided for an alternative dispute resolution mechanism. So we are introducing a tribunal. And why a tribunal, Chair? There's 3 reasons. Firstly, we know that the court processes, when the state is taken to court, and the court processes by their very nature are long. They take long. That's the first thing. And secondly, during that period, whilst courts are, of course, attending to disputes, the service delivery is heavily impacted. And the third part, of course, is that this thing is costly. I mean, not only costly for the state to litigate, but also for suppliers, especially the small suppliers who may not have deep pockets to take their matters to a formal court. So we're providing this particular dispute resolution mechanism. And what we're saying here is that we will compel the aggrieved suppliers to first exhaust this internal process before approaching a court in the event that they are not happy with the resolution of the tribunal. The tribunal will be chaired by a retired judge, and of course the members thereof also would be appointed by the minister, including the chair of the tribunal, and then all these other issues are outlined, what their roles are and the duties and so on, and their processes that they must follow is outlined in this chapter 6 in detail. Then the last chapter, Chair, is chapter 7. This is a chapter that deals with the general provisions. And here a provision is made for the Public Procurement Office within the National Treasury to investigate any procurement-related matter, not for purpose of criminalization, but more non-compliance, because we know that there are law enforcement agencies that are well placed to deal with issues of criminal investigation. This is simply to say there's an issue, there's non-compliance or there's compliance. That's what the PPO will do. And of course, the bill provides for measures to deal with criminalization, among others, what we're mentioning here around false information, misleading information, and interference and due influence, conniving and colluding to commit corrupt or fraudulent and collusive obstructive or act related to procurement. And of course, what the bill also provides is a limitation of liability for powers and duties performed in good faith. So I think it's very, very, very critical because I know that some people would tell you that, no, this is just a minor transgression, which was undertaken in good faith, and those people find themselves being prosecuted and so on. So the bill provides at least a limitation of liability in that regard. And the bill also provides for exemptions from the provisions of the Act as well as regulations, including departures from instructions. Now, unlike what we currently have in the PFMA and the MFMA, where this provision is open-ended, at least here we've set grounds set specific grounds on which those that want to be exempted from the Act, including departures from this Act, would have to comply before the exemptions or departures could be granted. And the minister, of course, will make regulations for all the issues that we mentioned from chapter 4. And the regulations, of course, Chair, would also be put out into the public domain so that the public, has a view thereof, and then they make comments on the regulations. This is not only on regulations, even the instructions that the PPO, the Public Procurement Office, including the provincial treasuries, the instructions that they are going to issue are also going to be published for comments, so that you avoid the conflict and the fact that there are many of them in the system and they're causing confusion and so on. And of course, the minister will have to consult on the regulations, especially with all other ministers, including, of course, provinces whose portfolios would be affected by those regulations. So the Minister of Finance would have to consult. And then, as indicated, there will be different regulations for different sectors of the economy, whether you're talking rail, you're talking energy, you're talking ICT infrastructure, bulk water, construction, etc., road, etc. There will be different regulations to this bill dealing with these different categories of commodities. And that would include also regulations for infrastructure, capital assets, and maintenance thereof. And I've just spoken to the fact that there would be public consultation process for instructions to be issued by the Public Procurement Office. Now, lastly, Chair, in closing, there's a provision for amendments to at least a total of 16 acts that are currently existing. And some of this piece of legislation will be repealed. Some of them will be amended. There's a schedule at the end of the bill that indicates what sections of those, number of pieces of legislations would be amended and which piece of legislation would be repealed. That's contained in the schedule, and the schedule is right at the end of the bill. And then there is also a provision which allows the bill to be brought into operation on different dates, of course, by the president. And then it also allows for differentiation, as we've spoken, Chair. A number of people would always say, no, we are this entity, don't treat us the same as this other entity, but the bill through the regulations will make that differentiation a reality. So that's the end, Chair. I quickly ran through this presentation, and thank you very much. Let me take it back to you, Honorable Chair, and thank you very much to the Honorable Committee members as well. Thank you, Chair. Back to you.
Thank you very much, Mr. Matsibule. Members, and as well to Advocate Master, if there are any questions or points, kindly raise your hand and indicate such. I recognize Member van der Westhuizen.
Thank you, Chair, and thank you for the presentation. Chair, I think if we go back, the history of public procurement has been a very contentious one in South Africa, and quite frankly, I think the aims in the Constitution may have sometimes been interpreted in a very narrow way, and that the wider socio-economic impact of public procurement may have unfortunately been neglected. And that is why we unfortunately cannot deny that some public procurement processes ended up in substandard goods and services being procured. So I believe that we will, when we go out for public comment, that we will probably have a lot of input from the public as it should be. And therefore, I wouldn't like to express any opinion at this point in time. I think we must go out with an open mind to the public to hear what they are saying. May I just, Chair, point out that we have now last night been informed about the election date. And I would like the presenter to take back to his department the following, and that is that they've been working on this bill since at least 2020. It was then introduced in the National Assembly on the very last day of June last year, knowing quite well that normally the National Assembly goes into a fairly protracted constituency period, which means that this was only referred to the National Council of Provinces on the 6th of December of last year, again, just before the National Council of Provinces went on to first a constituency period and then a recess. And now we've received this briefing. We also do know that quite often before the election, there is a constituency period again. I want to assure everybody that from our side, I believe, I speak on behalf of this committee, we will really go for a thorough public participation process. But I am concerned, Chair, and I want to register it here, that we are being put under immense pressure, not only by this piece of legislation, but by various other pieces of legislation, where those that were supposed to submit that to Parliament are sitting on their hands. There are even pieces of legislation that we can trace back to the previous term of Parliament. So, Chair, I want to object that such an important piece of legislation, which I presume would elicit a lot of public comment, that something like this is only brought to us and the National Assembly at such a late stage in the term of these parliaments. For that, Chair, I want to say thank you very much for the presentation. I'm not going to go into the detail. It is going to be taking us far too long, as I think there are a number of issues in this legislation that requires serious consideration. Thank you, Chair.
Okay, thank you very much. Members, are there any further questions? I note in I called on Advocate Marsdorp, but I believe that Advocate Mpokoela, sorry if I pronounced your surname incorrectly, is actually the legal advisor on this bill. Advocate, I don't know if you'd like to come in at all.
That is correct, Chair. I'm the legal support on this one.
All right. Okay, members don't seem to have any further questions. I guess I do have a number of questions, and so I'll just use this as an opportunity to put some of them forward, and I'll hold a few others where sufficient. My first is essentially I just like an understanding of where does the need for uniform norms and standards arise, and I ask this on the basis that we know in the Western Cape we have quite a track record of clean audits. And so it seems strange to have a uniform standard across all provinces, where some provinces, or in our case, the Western Cape, is able to manage this process quite well. And to what extent will it erase some of the good practices that we've already put in place when it comes to dealing with public procurement? And then I think when it comes to public procurement, one thing that makes everyone tear their hair out is essentially how long it can take. And I think one example that was given was the issue of school books or pens being procured at a national level. Now, to what extent will the bill actually institute backlogs or make the process of procurement much more longer than necessary as a result of it being centralized and having to take on so many procurement responsibilities? Then I'm curious about clause 30 and 31. I think this was under general procurement requirements, which related to IT. What I don't understand is we in every single province have had to implement MSCOA. We've had to implement a number of financial programs which are extremely expensive, and for some municipalities have placed a lot of burden on the pocket. Won't it be then a sunken cost if this procurement is then centralized at a national level? And how will it interact with existing IT systems that deal with procurement and that deal with the financial health of more localized levels of government? All right, with that, I'll hand over my questions. I'm just checking if the departments are able to respond to the questions.
Thank you, Chair. I'm going to start with the very last question that you've raised. Now, the ICT system is not going to be centralized. So all we're saying is every accounting officer and accounting authority would decide on a system that they want to use. Okay. So procuring institutions will have that flexibility, but the point that we're making, they must use ICT. So we're making them at least to be responsible to come up with their own systems. Because if you look, for instance, currently, take that the public entities have got their own systems, government departments have got their own systems. So this is not going to be an integrated system, not at all, like we currently have on the other systems that the chair has referred to. So accounting officers will have a discretion to decide on what system to use, but the bill is simply enabling people to make sure that at least they make use of technology. So that's one. And then the one other issue, Chair, around the centralization of stationery, pens and pencils, well, I'm not really au fait with what is contained in the other bills, but from where we sit in this particular bill, that should be the responsibility of the accounting officers and accounting authorities. So, but I don't know what is contained in the other bills that relate to education and so on. So, but the bill does not say we're going to centralize procurement of stationery. All we're saying in this bill is that the approach to that process should be strategic. So it can't just be that because you're doing pens and pencils, you procure anyhow. You must plan properly, aggregate the demand, and then follow a strategic procurement process when you procure. That's basically what we're saying here in terms of this bill. Then I think, Chair, if you allow me, I'll ask my colleague, Advocate Van Schoor, who is with me here in the office, at least to talk about the uniform norms and standards issue. I'm sure she can respond to that. Thank you very much, Chair.
Good morning, Honourable Chair and committee members. So we just firstly, on this matter of uniform norms and standards, I think that the first point that we're trying to make that currently there are different rules applicable to national, provincial, and national provincial public entities. And then on the other side, you have municipalities and municipal entities that are subject to a different regime. So it's appropriate to have the same norms and standards for those kind of institutions. Then this bill will enable it. We're currently sitting under two separate pieces of legislation. But we do make it very clear in the provision dealing with regulations that it's possible to differentiate between different types of procuring institutions, also between different types of procurement. So when you procure infrastructure, that there will be a separate set of rules. So it will not be like a single set of rules on how to procure. Then I just want to add something, just to take note that procurement decisions are still being made by accounting officers and accounting authorities if you refer to clause 7 of the bill. So it's not a case of that procurement will take place centrally through either our IT system and so on. But there is a requirement for Treasury or the Public Procurement Office to build a system so that people can access information about procurement across government. Thank you.
All right, thank you. I have more questions now than answers. All right, members, are there any further questions? Okay. I see Member van der Westhuizen.
Yes, thank you, Chair. Chair, can I just, for example, use the issue of CETA and the procurement of ICT equipment up to now? Will this legislation be addressing, for example, the issue that we've had up to now, where it was required of all organs of state to do their ICT procurement as a first option by default through the State Information Technology Agency, and that you had to apply for permission to be exempted from that, because I think that would be a wonderful development if that current regime or legislation could also be covered by this procurement bill. Thank you.
Thank you very much. I'll hand back to the department.
Thank you, Chair. A very important question. Look, what we're saying there, if you look at the schedule there, the CETA Act is one of those pieces of legislation that would be amended. And then what we're also saying is that the CETA Act will be subject to this bill. But as to whether or not they are, I mean, institutions would still be compelled to procure through CETA. I think that's something that we take note of. But at least the CETA Act will also be subject to this piece of legislation, Chair. Thank you. It is one of the pieces of legislation in the schedule to the bill. Yeah.
I think what would be helpful as well, just to furnish the committee, is if you could provide us with the list of legislation that would need to be amended. If there was any CS report conducted, and if that could be shared with us as well.
Yeah, we'll Chair, I think we'll liaise with the
Ms. Adams,
the advisor. Just to check, but at least the list of the piece of legislation that would be amended and so is in the schedule to the bill itself. Yeah.
Perfect.
Yeah, it's attached there. We'll do the CS report and all those other issues. We'll definitely provide those to the committee.
Thank you. Ms. Kwale?
Thanks, Chair. I just have a couple of concerns with regards to the criminalization aspect, right? So if you look, or if you can kindly flight the bill, the original bill, with your permission, Chair, there is just issues that I have picked up that may be problematic with regards to the power to enter and search premises, and when it comes to the issuing of warrants. And the question that I wish to raise is, when it comes to, may I proceed, Chair?
Yes, please.
When it comes to the issue of investigation, the individuals that are authorized to conduct the investigations, that is to seize items of individuals identified and to enter premises, on what authority do they enter their premises, save for the Act? Because typically, to have such powers, you would have to be cloaked with the powers of being a peace officer. And I don't see anything in the Act that addresses that issue, because those acts have constitutional implications. And then also, in terms of 27C of the Act, when criminality is identified, when is it referred to the authorities? Is it that the Act empowers that the investigation takes place first and then it's referred, or is it a concurrent referral? I'm not exactly sure, or it doesn't come across through the Act when the referral to the SAPS takes place. Thanks, Chair.
Thank you very much for those insights. I just want to call on the department to respond.
Chair again. Sorry, we're just muting on the side. Yeah, firstly, the first provision that deals with this is clause 57 of the bill as passed by the National Assembly, where we clearly indicate the purpose of these investigations is not for purposes of detecting crime, because we exclude any alleged commission of an offence. committed under the Act. And then to explain the rest of the provision, this is very similar to provisions that we have included or that Parliament passed in the Financial Intelligence Centre Act, as well as the Financial Sector Regulation Act. And it's been, even the particular act was subjected to the President referred it back to Parliament about constitutionality concern, and these issues were rectified. And even the amendments initially was triggered by judgments, and I'm quite confident we made sure that it complies with the Constitution. As to the point of referral is that if there's an investigation, and the purpose is obviously not to look for criminality, if they pick up any allegations or possibility of criminality, at that point it should be referred. But we will look at the provisions again and see if it's really clear that it must be done immediately. But the purpose is definitely not to investigate crime. It's just that if they come across any possibilities of criminality, then it must be referred to the law enforcement agencies. Thank you.
Thank you very much. All right, I just want to check if there are any final questions from members. Okay, none. With that, I'd like to excuse the officials from National Treasury. Thank you for joining us today. From our side, we're going to proceed on the way forward for both the bills that were briefed to us today. Thank you very much.
Thank you, Chair.
Good day.
Members, just give it a moment. I recognize Member van der Westhuizen.
Thank you, Chair. Chair, I presume that we are now going to move to a discussion on the public participation model to be used with these bills in front of us. May I ask, is there any opportunity of perhaps combining some of the public participation processes, running them in parallel? And secondly, of when we go over to public hearings, of having a hybrid model. I am concerned about, as I've expressed earlier, the timing and the workload of members over the next few weeks, now that we know more or less when you know, we will have to conclude these processes, and that you know, if members could save on traveling time, etc., I think it would be wonderful, because in that way we would be able to have an increased public participation model. Thank you.
Okay, thank you very much. Let's do it this way. I'm going to call in Ms. Adams, who can speak to the suggestions you've just made now. Then we'll move on and deal with the NCA bill, and then we'll move on to the public procurement in terms of what's proposed for the way forward. Ms. Adams, if you could just respond.
Thank you. In terms of Member van der Westhuizen's question, on the hybrid option, I think we discussed that on the group chat as well, and we agreed that it would be hybrid for both bills. It's just for the committee to now agree on the hearings, and then we can proceed from there.
All right, thank you very much. Okay, so members, I'm going to put a proposed way forward to you in terms of the small enterprises bill. And then you can just let me know if you're not comfortable with anything or if you have another thought on how we can approach things. All right, so in terms of this bill, the NCOP has provided legislatures with a program for the bills. The negotiating mandate is due the 19th of March, which is an extension we managed to get. The committee has already decided to hold one public hearing in Cape Town. This will be a hybrid public hearing to accommodate for in-person and virtual oral submissions. We have a choice of advertising in mainstream community newspapers as well as social media. The Western Cape Provincial Parliament has a paid social media policy. Unfortunately, they have depleted their social media budget, which means that we would have to consider funding that ourselves if we elected to use paid social media. The committee can also decide on which newspapers that we would advertise in. So, for example, with the upstream, we placed adverts in Die Burger, Cape Argus, Die Son, Westlande, Knysna Herald, Mossel Bay Advertiser, Courier, Bukani, and Overstrand Herald. We could also add George Herald, but this mix essentially ensures that we cover all of the district municipalities in terms of print media. From there, the advert will request that interested stakeholders submit comments either via email or WhatsApp. That could be voice notes or messages. And that if stakeholders would like to make oral submissions, they should indicate so, and then they will be invited to speak at the public hearing. The procedural officer, Ms. Adams, will then request that the Western Cape Provincial Parliament's communications sector secure radio slots for broadcasting a call for comments, in which case I can provide the voice note to be played on radio. To this end, Matthias would provide a media plan once the advertising is finalized, and this plan would essentially help include posting on the Western Cape Provincial Parliament social media pages, as well as any paid social media. From there, PEO will be requested to assist with attendance at the hearing through their network, and the Department of Economic Development and Tourism would be requested to send the advert and bill to interested stakeholders. Members, I would just like to check in with you on that way forward if you're comfortable or if you have any other thoughts on how to proceed. Member van der Westhuizen.
Thank you for those proposals. I propose that we support that, but that we also give you and the procedural officer the ability to liaise with other procedural officers, etc. As you know, we serve on numerous committees, standing committees, and numerous of those committees are now, in need of organizing public participation sessions, etc. And I foresee that we may have to, for example, have 2 sessions in the same venue on the same evening, that we may even have to combine advertisements to save on advertising costs. As you know, in many of these advertisements, there's a huge generic component in terms of, for example, where people must submit their inputs to, etc. So, Chair, with that, I want to fully support what you have proposed, but then also want to propose that we, as a committee, give you the freedom to somewhat deviate from programs of others as well. Am I audible? Because I think I may have been disconnected.
I lost you for a little bit. I lost you. I'd give you the freedom to.
Yeah, to liaise with other chairs, with procedural officers, in order for us to really reach the best efficiencies possible in the limited time available. Thank you.
Thank you very much. Member Seleko, are you happy with the way forward?
Okay, I'm very happy. Thank you very much. I'm covered, highly covered.
Okay, great. All right, then last but not least, we'll just look at the way forward in terms of the procurement bill. So before I get into the nuts and bolts of this, one thing that has become clear is that there is need for more public participation on this bill in particular. And so with that, while we initially discussed the need to have one hybrid public hearing, it's come to light that we'll need more. And so a strategic suggestion that is being made today is to have, instead of 1, 3 public hearings, which would include Cape Town, Stellenbosch, and George. At this time, the request has been shared with the Chief Whip to look at the possibility not necessarily to secure, because I still have to run this past the committee, but the possibility of having dates that we can have public hearings on this bill in particular for. So members, before I proceed with that, I just want to confirm if that's in order. Sorry, I said Stellenbosch, I mean Saldanha. Member van der Westhuizen?
I said agreed.
Okay, thank you. Member Seleko?
I'm okay, Chair. Thank you very much.
Okay, great. Once I have those dates, I will communicate them to the committee as soon as possible. But just to tie up this particular bill, essentially the NCOP has provided legislators with a rough program, and we have written to them to request the negotiating mandate be extended so that we can actually have meaningful public participation. We've agreed now to have 3 public hearings, and we've agreed to Saldanha, George, and Cape Town. What I'd like to put to you is the choice of advertising in mainstream and community newspapers, as well as social media. Again, the Western Cape Provincial Parliament's budget for social media is depleted, so we'd have to use our own in order to supplement that and ensure that we can still advertise on social media. So for the committee, I would propose that we use the same variety of mainstream newspapers and community newspapers used in the upstream bill to ensure that we are representative of each district municipality. The advert will request that stakeholders submit their comments via email and WhatsApp. So again, voice notes and messages. And if stakeholders would like to make oral submissions, they can essentially indicate this and will be invited to speak at a public hearing near them. From there, Ms. Adams will request that the Western Cape Provincial Parliament's communication sector essentially secure radio slots for broadcasting, calling on comments. So here I would provide a voice note to be played on radio. Matthias would also provide a media plan on the advertising once finalized. This plan would include, for example, the Western Cape Provincial Parliament's social media pages, as well as paid social media advertising. Then the Western Cape Provincial Parliament's PEO unit will be requested to assist regarding attendance at the public hearings through their community development workers as well as community coordinators. And then finally, the Department of Economic Development and Tourism, actually perhaps we can also add finance, would be requested to send the advert and bill to interested stakeholders. So members, I just put that way forward to you. Please indicate if you have any thoughts, if you are happy with this approach.
Happy? Happiness?
Great. Member Seleko?
Yeah, we are led by you. Thank you very much. We are led.
Oh, fantastic. Thank you. All right. And before I close shop today, I just want to check in and see if there are any resolutions that members have. Okay. Just a resolution from my side. I would like to get the CS reports for both of the bills. And then what would be helpful for the first one, NCA, would be the business plan for the Ombudsman. They had a presentation that they had initially made and they offered to present it to us. But I think given the timelines, as Member van der Westhuizen has correctly said, it is tight. So I think let's get rather the copy of the presentation, have a look at it. If we have any questions, we can always send those back. Can I get a supporter? Members?
Supported, Chair. Thank you very much.
Okay. All right. Thank you, members. It's been a very long morning. So with that, thank you for your time. Also, thank you to all the members of staff and officials who've joined us today. Thank you for making this possible under very impossible circumstances. We really appreciate all of your hard work. Meeting adjourned.
Thank you, Chair. Thank you, colleagues. Bye-bye.
And we're seeing each other tomorrow? Are we seeing each other tomorrow?
Yes, we are. Member Van der West says, and it's a hybrid meeting. And we'll see each other on Friday.
Yes, thank you. Thank you.
Okay, bye.
Thank you. Have a good day.
You too, bye.